not here. I am Daniel Wolf. I'm the Executive Director of the Computational Precision Health Program, which is a joint program with UC Berkeley and UCSF. I see that there are some colleagues here who may not be familiar with CPH. So let me just say that we are a relatively new program that leverages the top tier clinical expertise, research and informatics at UCSF, the world leadership in computer science and engineering at Berkeley, and the commitment to population health at both institutions. I'm glad to welcome you on behalf of our co-sponsors, the Center for Healthcare Marketplace Innovation and the Berkeley Center for Law and Technology, BCLT. All of us share a commitment to moving beyond discovery to deployment and real-world impact. And for that reason, we find ourselves negotiating not just the unfamiliar advances or the astonishing and important advances in computation and in artificial intelligence, but also the somewhat unfamiliar terrain of moving from research to publication to commercialization, from open science to intellectual property protection, from Jupyter notebooks and open code on GitHub to discussions of trade secrets. So for all of these reasons, we are very glad to welcome Allison Schmitt to our talk today. Allison, in addition to her role as the inaugural director, Allison basically, she brings a long experience in many different aspects of patent commercialization, patent counseling, and the pathway from innovation to commercialization in the life sciences. She has clerked for justices at the state and at the federal circuit. She has a PhD in chemistry. And yeah, Allison, we're very grateful for your attendance and look forward to your comments. If you can try to leave us some time for questions at the end, we'll be grateful. And I know that you will tell us a little bit more about your role and background, but really, thank you for joining us. Thank you for your work, and the floor is yours.
Thank you so much for inviting me to come and speak today, Daniel, and it's a pleasure to have all of you here. I'm going to share my screen. I think I've given Daniel, Daniel, I'm going to give you a different copy of the slide deck. I tweaked a few things, but I'll give you that afterwards. But I'm happy to have the slides distributed from today's talk.
Okay, and yes, I'm happy to distribute to all attendees, and in case anyone didn't make it, I will also share the slides.
Wonderful. All right. So we're going to cover a broad landscape in the next 45 minutes or so. I guess what I will say off the top is that I could probably talk for hours about each of these topics. For example, that diligence topic at the very end of the list is something I teach an entire semester on with our law students over at Berkeley Law. So the goal here is to give you the highlights, to give you some sense so that you're starting to get a feel for the context and the way in which we think about intellectual property in this space. So I've got a couple of basics that we need to go over in terms of talking about patents before we kind of dig into the question, thinking a little bit more strategically about how you patent algorithms and outputs. I will say that this area is fast moving. I think that certainly in terms of the implications of artificial intelligence and how that's going to play into patenting, there are some very open questions that we just haven't had court cases we haven't had law on yet. So I'll give you a snapshot of where we're at right now, but I guess my big message on that piece is going to be stay tuned. And then we're going to switch over and talk a little bit about trade secrets, which I think are another important potential weapon in your arsenal when you're thinking about how to fully protect inventions that are based in algorithms. And then finally, we'll spend the last few minutes talking about diligence. And what I mean by that is the process by which, when you're trying to get funding for your invention or for your product, how do you convince somebody to give you money? The answer is that at least part of the analysis related to that is going to be related to your intellectual property portfolio and some other related issues in terms of non-disclosure agreements, licenses, those types of things. So I've done a bunch of deals in this space, so I want to talk to you a little bit about sort of, pulling back the curtain and sharing with you, what things look like, what buyers are looking for. So I think Daniel's going to be collecting questions as we go. I am going to do my very best to leave about 10 minutes at the end for questions. And so, but let's go ahead and get to it. And so Daniel already did most of this, so I will very briefly say that. So I direct our Life Sciences Law and Policy Center over at Berkeley Law. I lecture on these topics. I am also a research fellow at Berkeley Law. I spend a lot of time thinking about questions, including artificial intelligence and algorithms and how those play into life sciences innovation. Please feel free to connect with me on LinkedIn. I'm happy to talk more offline if there are more questions that come up. I will say that my caveat here is that I am not your lawyer. Do not tell me anything confidential at any point of during this. I don't want to hear about it. It's going to cause you problems in the future. I'm also not providing legal advice. I'm sharing with you how the law works, but I'm not giving legal advice as part of this presentation. So before we dig into the nuances of patents and trade secrets, I want to take a step back and think a little bit about what is the landscape of intellectual property? What are the various types of rights that you can use to protect your invention? And so in the spaces that we're talking about today, there's at least 4 rights that may be relevant to developing your portfolio. So patents, which give you a right to exclude others from using your invention. Trade secrets, in which you're keeping your invention or your development secret. Copyright, in which you may be claiming various ways of expressing ideas. And then trademarks, which can come in a couple of different flavors. You can protect a word in an actual trademark, or you can protect trade dress, the way in which perhaps, you've designed your product, you have your product packaging, that type of a thing. I think the default is often to assume that I want a patent. Patent protection is the end all to be all. It's the thing that we want to make sure that you have. I guess I'm starting here because I want to say that, especially in the algorithm and in the AI ML space, I'm not convinced that that's true for every aspect of inventions. So there are certain areas, and we're going to talk a little bit more in detail in the ways in which patent protection may make a lot of sense. But there are other rights that you're going to want to be aware of and that you may want to think about in terms of creating. We talk about it as a portfolio. So early, I almost think about it, your invention is your castle, thinking about the moat of protection that you want to put around your castle. And so there's a variety of different ways that trade secrets, for example, are relevant, which is why we're going to spend time on that during the presentation. But for things like manufacturing processes and know-how, and then for reasons we'll talk about a little bit more in a minute, for algorithms or for training data, trade secrets may make more sense in certain scenarios versus patents. I think the broader, 30,000-foot view on all of this, though, is that all IP issues are really coming from 2 business objectives. The idea being that you want to have freedom to operate. This is a term that we use to talk about the idea that you can go forward without infringing someone else's patent rights and getting yourself into trouble and potentially getting sued, but that you also want to find ways to protect your own invention. And so what we're going to be talking about for the most of the presentation are going to be various different considerations in terms of thinking about which rights you're going to want to use and in what different ways. So I know there are some folks on this call who are very familiar with patents. I believe there are also some folks on this call who are not very familiar with patents. So I want to say a couple of different things about the terminology that we use and the features that are going to be important as we go forward. I also want to talk a little bit about what is it that you actually get from a patent, because I think there can be assumptions about what different ways you can use a patent that don't actually line up to what the right actually gives you. So there are a variety of different features in a patent. I've taken some screenshots here from a pretty important patent in the CAR T cell therapy space. It's an example I like to use with my students, but you can pick any patent that you want. Go to Google Patents and find something and kind of take a look. I think it's useful to take a look at them. Certainly something that I didn't have a lot of familiarity with when I was doing my PhD. But it's useful to know what the parts of a patent are, what pieces you would need to put together in order to put together an application. The 2 biggies that we're going to talk about today are the specification and the claims. So the specification, it's the long-winded part that comes after the front page of the patent until you get to the claims at the very end. So the idea here is that you're supposed to be describing your invention in detail. You should be giving examples of implementations. You should be giving various different options that can be used. And then we use the term embodiment, various different ways in which what you have claimed in the patent can be expressed. And then the claims are really critical in terms of in terms of defining the scope of the patent and the right that you're going to have. So in the United States, your claims are going to look like this. The idea being is that you're going to create a series of claims that are describing your one invention that you're encompassing in the patent. So you want to describe the features that you're going to have. You may have certain claims that add additional limitations. You may have certain claims that stand alone. The nuances of that aren't as important for what we're talking about here. The take home here on the claims piece is that the claims define the scope of the invention. What you have in the specification may describe significantly more than what you've actually claimed in the actual claims of your invention. But when you're thinking about what the scope of your patent is, what you're going to be looking to is definitions and what you've actually put into the claims itself. So this language here, it feels very formulaic if you haven't seen a bunch of these, but it's very important. And it's the way in which patent practitioners are thinking about what the scope of your rights are. So what do you actually get when you have an issued patent? So you've gone to the patent office, they've looked at your patent and they've said, yes, you may have a patent. So it's not the right for you to be the only it's the right for you to exclude others from practicing the technology. It's not the right for you to necessarily be the only person who's operating in a space, for example. So you can exclude other people from making or using your invention or for selling or offering to sell the invention. It's a limited duration right. Patents, if you went and filed a patent today, for example, or any patents that were filed after June 1995 are going to receive a 20-year term from the date of filing. And so why does this term matter? So if your patent has expired, if you've gone past that 20 years, you can't exclude other people from practicing your patent. So limited duration right, but a right to exclude and an ability to enforce. So you can take that patent, you can go to court and you can sue somebody for, we call it a patent infringement. So you can sue somebody for infringing your patent for practicing what's described in there. You also have the right to license your patent. You can assign your patent away and you can transfer your interest. You can sell if you choose to do so. So let's dig a little bit deeper in terms of how we think about patenting algorithms and outputs. And we're going to touch on 4 different buckets here. I'm going to talk a little bit about inventorship because especially in the AI space, this has become a hot topic, something that we're discussing and that the courts and that the U.S. Patent and Trademark Office are still trying to figure out what the contours of this are. We'll talk a little bit about what the requirements for patenting are in the United States and how those play into various algorithm and output patents that you may be thinking about. Talk a little bit more in detail about the types of patents that you might be able to receive in the space, and then talk a little bit about infringement and enforcement. So we're going to start with inventorship. Because I think it's important to think about the concept. So each patent has one or more inventors who are responsible for developing what is present in the claims. I think if there's one thing that you take out of this section, it's that inventorship from a patent perspective is not the same thing as academic authorship. So those two standards, oftentimes that group of people can overlap. Sometimes the Venn diagram completely overlaps. Sometimes it does not. And so that can become kind of tricky when you're dealing with it, particularly in an academic context. So in the United States, inventors have to be human under our current case law and statutes. So inventors have to be natural persons. The courts have decided that means that they have to be human. But the term inventor refers to one or more individual humans who invented or discovered the subject matter of the invention. By subject matter, we mean what's described in the claims. Usually, you're talking about joint inventors. So the patent statute gives us some guidance in terms of how you can apply for a patent jointly. So you don't have to be working together at the same time on the exact same thing in order to be joint inventors. You don't have to contribute in the same amounts. You can contribute unevenly and still be joint inventors. You also do not have to contribute to every single claim in a patent in order to be an inventor. So, but in order to be an inventor, you have to contribute to developing what is described in at least one claim of the patent. We talk about this in terms of a term called conception, which the case law gets very crazy very quick with this. But the idea here is that you have an idea that's definite enough that someone who is familiar with the space could, we call it reduce to practice, could actually take that idea and they could turn it into the invention that you've described. So you can describe it clearly enough, you understand it clearly enough that somebody could execute. And that can be somebody besides you could execute in that scenario. But the take home here is that in order to be an inventor, you've got to contribute to at least one of the claims. So there are fairly significant consequences if you don't correctly identify your inventors. It gets fought about in court more than you would like. Usually we try really hard in the patent space to fix those issues before you get to court, because they tend to be very fact-heavy inquiries. They tend to take a lot of effort to figure out, oh, well, this person did this based on their lab notebook 10 years ago, those types of things. And so you can end up having your patent rejected if you've got the inventors wrong. It also changes the ownership of the patent. So each owner of the patent has the right to license and to push the patent forward independently. So we have to talk a little bit about what the requirements are for patenting in the United States in order to be able to dig in a little bit further. I spend weeks on this in IP class, so I'm going to do it very quickly, but happy to provide additional resources if that would be useful. So we've really got 5 main statutes that we look to here that are all part of our Patent Act, all part of the rules that we follow in the patent space. And so I'm just going to go down them numerically. So subject matter eligibility is an important one for what we're going to be talking about today. So the idea here is that in order to be eligible to get a patent, what you're describing in the patent has to fit into one of a few different buckets. So it has to be a process, a machine, a manufacturer, or a composition of matter. And it has to not be excluded by various rules that the courts have developed for things that we think shouldn't be patentable. So we'll talk more about what those rules are in a minute. We also have a utility requirement. So it has to be useful, and we mean that in a couple of different ways. It has to work for an intended purpose, and it has to serve a practical purpose. So we don't want inventions on things that are completely impractical or not useful. And so this is meant to be a very low threshold that you have to get over in order to be able to patent. So novelty, at its absolute core, what we mean by novelty is that the invention has to be new. It has to have not been put out in the public in identical form in any sort of record of the prior work in the field. There are a whole host of rules that surround novelty that make it a lot more complex than what I just said. But I think for the purposes of what we're doing today, that should be totally sufficient. It has to be new. So we also have a non-obviousness requirement that goes really a step beyond the novelty requirement. So it's trying to measure something that is even more abstract, perhaps, than what we've talked about in novelty or utility. So what is the technical accomplishment of the invention? Did the invention make enough of an advance over the prior art that we should give it a patent? So is it enough of a step forward? Is it not? We're not looking to give patents to things that are incremental or small leaps. We want to give it to something that it's enough of a push forward that it's deserving of that right. If you're thinking about this and you're thinking that seems like a really murky standard, you're right. And that's one that you fight about a lot in the courts, because what does that mean? You end up talking to experts. You end up talking to most of you who are on this call today, who are dug in the technology, and you really want to understand what it is that they would have understood, what they think the leap would have been. And then finally, there are some requirements that I've lumped in here about disclosure. So the patent specification, you have to give enough information to somebody who works in the space. We call this person the person of ordinary skill in the art. Enough information that they would be able to use the invention going forward. And so this really goes back to a quid pro quo that we talk about as part of the patent system that I think it's important to spend a moment on. So the idea here is that you're given this right to exclude others for a limited period of time, but in exchange, you're giving the public information about how your invention works. The idea being that once your right has expired, that you will have the ability to go forward and the public can build upon it at that point. And so we have two criteria for that. One of them is called written description. So the idea here is that you need to show that you actually had possession of the invention at the time that you filed your application. You need to describe enough in writing that somebody who is up to speed in the field would understand, hey, I think they did actually invent that. The second requirement is called enablement. So the idea here is that the specification has to describe enough about how the invention works that someone who works in the space would be able to make and use the invention based on the description. So that requirement means that oftentimes, especially in my life sciences world, and if you go take a look at the 682 patent that I put up before, I think that one's about 75 pages long. It's not crazy to see 300-page patents in the life sciences. I think if you're looking specifically at algorithms, they're going to tend to be shorter than that, but you can end up with pretty voluminous patent filings in order to be able to describe the amount of information that you need to be able to describe. So let's dig in a little bit deeper on that subject matter question, because it's an important one for the algorithm piece. So as I said before, there are certain buckets that your invention has to fall into in order to be patentable. So composition of matter, like a pharmaceutical drug or a paint formula, something that's been manufactured, a table, notebook, water bottle, a machine, a process, or you can also patent improvements to any of these particular things. But the Supreme Court has decided that there are certain types of inventions that may actually fall within these patentable buckets, but that we don't think are worthy of a patent, mostly because they're going to block other people from inventing and developing in those spaces. So we call these the judicial exceptions, and there's three of them that we really focus on. So one of them is abstract ideas. You're not allowed to patent a mathematical equation on its own or an algorithm on its own. You're not allowed to patent a law of nature. You're just blocking too many other people from inventing in a space. You're not allowed to patent a natural phenomenon. That law of nature, natural phenomenon thing, those two things oftentimes go hand in hand together. But the abstract idea piece is really important for what we're talking about today, in the sense that you cannot patent a naked algorithm in the United States. So there's a variety of other things that, based on these judicial exceptions, become pretty difficult to patent, and some of them that are just not allowed based on either subject matter requirements or other various rules. You can't patent humans, for example. Or the most recent version of the Patent Act says that's not allowed. So, can't patent things that are impossible, don't want to patent things that are contrary to the public good. But this bucket up above of things that are challenging, at least, to patent, is very relevant to what we're talking about here. So algorithms, other abstract ideas. So you can't patent them on their own, but you can patent them if you transform them into a patent eligible invention. And so the rule that we follow, and it's very murky, I will be honest with you, the case law in this area doesn't really make a lot of sense. But what we've been told by the Supreme Court is that if you can find a way to transform the invention by finding an inventive concept, that it's okay. Oftentimes, what people will use is as a way, for example, describing that, hey, this algorithm makes this computer work better. So if you can make an improvement to a computer or software, you can patent that. If you're really looking for things that feel more concrete, less like naked algorithms as part of this analysis. But it's a challenging hurdle to get over for algorithms on their own in the space. And so I think part of the reason why Daniel invited me to come talk about this is to say that to you. So what about AI? Well, the reality is that I think we're still in the process of figuring out what the patentability of AI is going to look like. But we do have this rule about algorithms. And so, just saying, hey, there's AI involved isn't really going to change the calculus on that front. So what I think we can say at this point, so there have been some cases related to inventorship on AI ML inventions. So what we understand at this point is that inventors must be human, and AI cannot be listed as a joint inventor. So you can't say Allison and Dabus, which I think is the case example. You can't say Allison and your favorite AI. The United States Patent and Trademark Office is allowing patents that have contributions from AI ML, so long as at least one human can be considered to be an inventor. So the way in which they're doing the analysis is to focus on what the human contribution is rather than what the contribution of the AI is. And the standard that we're supposed to be meeting is that a human must significantly contribute to conception. The standard came out 2 months ago. I'm not sure we know what it means quite yet. The idea here is that you cannot patent something that the AI did on its own. It is challenging to patent something where the AI has done most of the heavy lifting. So some advice that I think is useful is that thinking about how you're constructing your prompts is pretty important. So it's probably not going to be enough to just identify a problem and ask AI to solve it. I think what you want to do is be specific and offer the AI guidance on how it's going to achieve various elements of the solution that you're working towards. You want to show that you were really driving the train, not the algorithm. You know, another way in which you can effectively show your human contribution is to refine and improve what the AI has spit out, you know, to do various iterations and to document your efforts. But this is still very much in movement in terms of what the standard is going to look like and what's going to be required. So the other thing I'll note is that those are the rules in the United States. Other jurisdictions may have other rules. So for example, in this Davis case that I was talking about, so Thaler versus Vidal in the United States, but Stephen Thaler, who was doing work with a Davis, he called it Davis, but an AI system that frankly didn't make significant contributions to what was being developed. And I'm not from technical perspective, I'm not totally convinced that it would have been a joint inventor in any case. But he basically floated the idea that the AI could be an inventor at various jurisdictions around the world to see what would happen. And in some places, he won. And so, for example, I believe in South Africa, AI can be an inventor. So, you know, different jurisdictions, different rules. I imagine things will continue to shift. So a couple of other considerations to keep in mind when you're thinking about AI ML patentability. And really what I'm about to say here is very much theoretical, in the sense that we have not had test cases to come through the courts yet to really figure out what the contours of the novelty, obviousness, and disclosure doctrines are going to be in terms of AI. But keeping in mind that you really want to be able to show what it is that you've done that is new. You know, applying a well-known AI system to a problem that has been studied before and getting a predictable result. I think that's going to be more challenging than showing exactly where your novelty points are. On the obviousness question, there's a fairly famous theoretical law review article entitled "Everything is Obvious." It's one professor from Australia's theory about the idea that perhaps once we're using artificial intelligence, you know, as part of the inventing process, maybe everything will become obvious. So, you know, I think it raises a real consideration, though, in terms of we don't have a good understanding yet of how the courts are going to view the use of AI ML in the inventing process. Everything else that we've worked with before feels a lot more like just a regular rote tool. And so tools are not used, you know, tools do not become inventors. Tools are viewed as being driven by the inventor. You know, if there's things that we don't understand, if there's things coming out the other end that are less familiar to us, I think the courts are going to find some discomfort with that. So how this is going to play out, unclear at this point. What the standard is going to be, I can tell you the patent office is issuing a whole bunch of patents, but whether or not they'll hold up in court in litigation is a different question. And then finally, questions about disclosure. So beyond the question of how much do you have to describe so the person of skill in the art can actually make and use, you know, there can be challenges in describing, depending on what it is that you're trying to claim, there can be challenges in describing those features in a way that's useful. You may have limited examples of how your system worked, but you may want to have a much broader claim. The rationale for having a broader claim, the broader your claim is, the more potential threats you can exclude, the fewer ways in which people can potentially design around your invention. So within reason, broader may be better if you can still satisfy the patentability requirements. But the challenge there is that if you have a broader claim, you have to describe more in the specification. You have to show that you've invented more. And that can be challenging. And that's not just a problem in the AI ML or an algorithm space. That's a huge problem in the life sciences space as well. So, you know, not the only area in which folks are facing this. So one question that I encourage you, if you're thinking about patenting, to ask yourself is, what specifically do you want to patent? So the rule in the US is that you can only have one patent per invention, but you get to decide what the scope of your invention is. You get to describe how you want to claim it. You get to describe you decide how you want to describe it in your specification. And so you may be interested in protection on certain portions of your invention, but maybe not all of it. And so some of these areas, so I've offered up some examples here. I don't think that these are exhaustive, but these are intended to get you thinking about the types of ways that you might want to claim, that you might want to explain what your invention is to the patent office. So you might be interested in some sort of protection related to your training data or your data compilations. So you might be able to patent certain elements of it. So if you're doing a new way of preparing or enriching your data, if you can describe a new way in which your ML model is being trained using data, maybe you're using synthetic training data and you can explain your process for that. Or, you know, how your training data is being tested or evaluated. I will say though, and we'll talk about this more when we talk about trade secrets in a few minutes, I think that there's a real live question out there about whether or not you'd want to disclose your training data, particularly if it's the major value of your invention. You know, the idea being here is that, yes, you have the ability to exclude other people from doing exactly what you did, but does it make more sense to keep that data secret and to be able to keep that as a proprietary trade secret rather than disclosing this information publicly? So I think there are advantages to going down the trade secret route. We'll talk more about that in a few minutes. So as we've talked about, algorithms aren't going to be patentable in the abstract. You're going to need to transform it into a patent eligible invention. You really want to tether that to the idea of the types of improvements that you've made, whether it's improving, you know, the process that you're trying to work through, whether it's improving the output. You're going to want to be able to tether it concretely. You may be able to get a patent on how you're actually using the AI ML model, what your method is. In order to do that, I think probably best practice is to really describe in detail how the model is tailored to the specific application. You really want to tether it in that way. The architecture of your model may also be patentable, especially if you're using a custom architecture. Things like weights, coefficients, biases, other parameters, I think they start to feel to the patent office and the courts more like they're algorithmic or mathematical formulas. And so you start to wander into that abstract idea land again. And so oftentimes inventors will use those various parameters as part of trade secret protection. I think it's at least somewhat, perhaps pretty common, to be patenting the output or the end product. So in my world, you know, if you're using an AI ML system in order to generate new drug leads, you certainly would want to patent the leads. You know, you want to patent the drugs that come out of the back end. You know, it provides you protection. It provides you the ability to keep somebody from copying, you know, the protein sequence or the structure that you've come up with. And as we're going to talk about on the next slide, or I think 2 slides from now, it's something that you'll be able to figure out if other people are using your technology. I think, you know, sort of taking a step back as you're thinking about all of these different options, one of the questions that you want to ask yourself is, if I get this patent and I spend all of this time and money investing and trying to get this patent, what do I want to do with it? And the answer for many people is, well, I want to be able to enforce it. I want to be able to prevent other people from using the technology that I've claimed. And so one of the big questions that you have to figure out, and I think it's very hard for some of these types of inventions, is how do I figure out if somebody's using it? So, you know, in an output, you know, an end product, it can be a lot easier to figure out the answer to that question versus some of these others. And then finally, if you have a new or novel user interface, that might be something that you're interested in doing. So it may be patentable. You know, we have utility patents, which is mostly what we've been talking about. We also have design patents. You may be able to patent it that way. User interfaces you can also do with copyright. May be more straightforward to do that. So beyond sort of breaking down the types of inventions that you may want to think about, I offer you a few other strategic considerations that you may want to ask. And so this first bucket I'm going to call features of invention. So if there are features of your model or your invention that are easy to reverse engineer, or that you're going to have to disclose to the public as part of what you're doing, you might want to consider patent protection in that scenario. If you already have to disclose it anyway, you're not necessarily trying to keep anything secret. So it may make sense for you to pursue protection that would allow you to exclude others. Are there technical features or details here that aren't routine? That would be a good way to show the patent office that, hey, you've come up with something that's new, novel, and non-obvious. Other considerations to have, I think, especially at the early stages, and I think for many of you who may be coming out of CPH, maybe you're thinking about startups, maybe you're thinking about very early stage. There's always significant funding issues, especially at the beginning. The patenting process is not cheap. It typically takes, I think, on average, at least 3 years to get through the process. You're going to be spending a lot of money with patent office fees. You're going to be spending money on lawyers. And especially in the space that we're talking about today, many of you may be generating many versions of your invention. And so the question is, do you want to patent them all? That's going to be spending a long time in the patent process. You're going to be spending a lot of money to patent iterative inventions. And so you may want to ask yourself, are there versions here that are more valuable that you really want to focus on protecting? Another big question is, how long do you need protection for your invention? So as I set up at the top, so patents, you get 20 years from when you filed your non-provisional application, so your main application. So do you need protection for 20 years? I think that's a very live question because of how quickly things are moving in this space. Do you need to be able to exclude competitors for your business model to work? I think this is a different answer for different business models. And then finally, back to the question that we were talking about a little bit earlier about how inventors work. So have you, as the human, made a significant contribution to the invention that you're claiming? Are you going to be able to demonstrate that? If the answer is no, then perhaps we should be thinking about other forms of IP. So I think I've already talked a bunch about the detectability thing, so let me just say a couple of other pieces here. So detectability is going to be a real issue if you're doing an algorithm-based invention, in the sense that how are you going to figure out whether or not the other person infringed? So you can get discovery, so you can get information. So if you sue somebody, you can collect information from the defendant as part of a court case, but that's going to be very expensive. And so it is a strategy that's used by some folks in the space who are patenting, that you may want to focus more on the inputs and the outputs to the system, because those are easier to figure out if somebody is copying and using what you've described. In terms of enforcement, you want to give consideration to a number of things, including the following. So where have you filed for patents? In what jurisdictions? The next slide, which I'm not going to spend a lot of time on, it's got a set of questions that you may want to think about in terms of where you're going to file for patents. But usually you're looking for protection in the markets that you're going to be marketing in, or in the markets where your competitors are. That can get very expensive very fast. You file for a US patent generally separately from patents that you have in other jurisdictions. And so if you need to be protecting in a lot of different places around the world, very expensive very quickly. Do you want to be able to use patents as licensing tools? So is it useful for you to be able to say, hey, here's my invention, why don't you license this technology for me? Or maybe we'll create some sort of joint collaboration agreement. That can be a reason to go forward with patenting. And I think the $64,000 question is it truly strategic for you to sue your competitor in that scenario? What's your real end goal here? Litigation is never a sure bet. Even if you think you have a sure bet, 20% of the time you lose. And so it's taking on that type of expense and time. It's not just paying your lawyers. It's the amount of time that's going to take away from the leadership in your company in order to be able to be involved in the litigation, because they're going to have to get involved in the litigation. It's a very expensive, it's a very time-consuming endeavor. Is it something that you really want to take on? Let me say two brief things about avoiding infringement of other people's patents. So If some of you are thinking about the process of spinning out and turning into startups and potentially getting funding from various VCs or other groups, you may have heard the term freedom to operate floating around. Lawyers love throwing that term around. And especially, if your invention touches on something related to the life sciences, we extra love throwing that term around. So what do we mean? What is freedom to operate? So the definition of it is that the company, so you as the startup, can do what you want with it without infringing the valid patent rights of a third party. So the idea is that the landscape is open for you to be able to operate in. So freedom to operate and patentability are related concepts, but they're not exactly the same. So when you're looking at freedom to operate, you're asking the question, does your technology infringe somebody else's patents? With patentability, you're going back to that list of statutes we talked about earlier and asking yourself, does my invention satisfy the legal requirements for patentability? Oftentimes factors will end up playing into both of these questions. But you end up looking at freedom to operate as part of thinking about your startup strategy moving into a particular space. That all being said, for the reasons that we've talked about here, you can imagine that many of your competitors may not be interested in patenting certain portions of their invention. There may not be, a flotilla of algorithm patents out there for you to fight through because they may not have been able to get patents on those particular inventions. So, although I think it's useful and pretty much necessary in order to get funding to understand what the landscape is out there in front of you, I tell you that this with the caveat that you might not find a lot, or you might not find a lot as to certain aspects of your invention because they may not have been patented. So if you do have a risk, if you do find a patent that you potentially infringe, you're going to want to consider potential design around options. You're going to want to think about the process of, okay, well, how do I avoid infringement? The answer there is either you need to change what you're doing, or you need to be able to say, well, this patent that's a potential obstacle, it may be invalid. It may not be deserving of a patent, and here's how I would get rid of it. If you're interested in this topic, I teach an entire semester-long class about it. I'd be happy to talk to you more about it. So let's switch over to the topic of trade secrets. And so we've been talking about patents, the rationale for why you might want to get a patent, some of the downsides, especially for this type of technology. So what exactly is a trade secret? I've thrown that term around several times, but let me define it for you. So we define it as information that's economically valuable, that's not generally known or readily ascertainable, something that's not easy to find. Trade secret has to have value to those who cannot obtain it legitimately. And a trade secret has to be subject to reasonable efforts to keep it secret. So in the law, we love this word reasonable. You end up going to court to define exactly what that means oftentimes. But the idea here is that if you were trying to hold a trade secret, you need to show that you have made efforts to not have that information get out to the public. So several key features to keep in mind. Trade secret can in theory go forever. So there's no statutory limit. There's no 20-year period. So, Coca-Cola has been rolling for over 100 years with the recipe on their Coke formulation, and nobody's cracked it yet. So it is possible to keep a trade secret for that long if you're doing a really, really good job of protecting it. You don't have to disclose anything. As a matter of fact, you absolutely should not disclose anything related to a trade secret because it's going to destroy the trade secret. But here's the challenge. So independent discovery and reverse engineering of a trade secret is totally allowed. So the idea is you're keeping the information secret, but your competitor independently discovers the same thing that you do. That destroys the trade secret. If your competitor legitimately obtains your invention and is able to reverse engineer it, totally legal, destroys the trade secret. And so trade secrets can be extremely useful for certain types of information, but where reverse engineering is straightforward or where there's a significant risk of independent discovery, that's a scenario where if you are eligible for patent protection, you may want to think about doing that. So it's really, I view it as a balancing act in a lot of different ways. So unlike with a patent, where you're allowed to sue if somebody uses your patented method or technology, call that infringement. Infringement is a strict liability offense. If you do it, you can be sued. In trade secret land, you have to be sued for something called misappropriation. So it's not enough just to use it. Misappropriation is the acquisition of a trade secret by someone who has reasons to know that they got it illegitimately. So somebody who's used the improper means to acquire the knowledge, they knew that they got it from somebody else who used improper means, they knew that the secret was subject to some sort of duty of confidentiality, or they knew that it was mistakenly given out. So you have to be able to demonstrate that, not just the idea that somebody used it. So variety of examples here of things that have been successfully protected as trade secrets. So things like your training data, you can structures and formulas used in your model. You may want to protect the particular method of using your model, outputs that are converted into end products for customers. From a broader perspective, sort of stepping back from the algorithm and model discussion, things like customer lists, which aren't going to be patentable. Manufacturing techniques or refinements. It's a pretty common way. You may want to, protect a proprietary product design, some experimental data. Your patent applications that haven't published are actually trade secrets. Your business plans, negative information. What I mean by this is all of the different ways in which you failed. That can actually be incredibly useful information to have that you may not want your competitors to get a hold of, and you absolutely can protect that as a trade secret. Exemplary, not exhaustive on this list. So what types of things should you be doing in order to protect your trade secrets? So robust non-disclosure agreements, I think, is the biggest key here. And you may want to consider non-compete agreements as well, although the enforceability of those is a little bit more challenging. Really, what you want to show is that you're controlling the flow of information in and around that trade secret. So keeping track of which employees have access to it, training employees and how to handle trade secrets properly, documenting how you protect your trade secrets. We'll talk about this in a second, but you're going to get asked for how you're actually protecting your trade secrets as part of diligence. Restricting the access of third parties like vendors to be able to get a hold of that information. We usually recommend, at least when I put my former practitioner hat on, you want to have your employees sign an NDA on the way in, and then you want to do an exit interview on the way out and remind them that, hey, you signed an NDA and you mean this, and maybe you make them sign another one. So those types of procedures are part of what the court is going to look at to figure out if you've made reasonable efforts to protect your trade secret. So the next few slides I've put together, and we're not going to, given the time, I don't want to drill down on this piece, but for your reference, I put together a comparison of the various different features of patents versus trade secrets to help you sort of work through the question of which one of these rights might be the right for me, depending on what type of invention or what feature of the invention that you're trying to claim. We've talked about the big parts of this here, but I just want you to be aware that it's in the deck. So some strategic considerations to give thought to as you're thinking about the question of patents versus trade secrets. So, we've talked about the fact that you're not going to be able to get patent protection for certain subject matter versus the risk that you have for trade secrets for, independent discovery, reverse engineering, accidental disclosure, those types of things. Length of protection, you've got two different ways of looking at that going forward. Certainly with patents, you know what your term is going to be. But then the patent expires and the invention goes dedicated to the public. With a trade secret, as long as you're maintaining your secrecy, you can keep it forever. Patents can be really expensive. You have to file for them, you have to maintain them after you get them, and you may have to enforce them. So going to court is not cheap. Trade secrets, they can be significantly cheaper in the sense that it's going to be whatever the cost is to secure and maintain and to keep track of that information. So generally patents are going to work better where it's easy to detect inputs and outputs. If you have a scenario where it's harder to detect those things, maybe trade secrets is the right way to go. So this next thing called criticality, what I really mean there is that, do you think having the threat of a patent would meaningfully alter what a competitor does? How they're going to behave, how they're going to operate in your space? How absolutely critical is the invention to your market success? If you had it as a trade secret and the trade secret became disclosed, how catastrophic would that be to you? Are there challenges that you're going to face going forward with maintaining confidentiality with your invention? If it's going to be hard to keep it secret, maybe you want a patent. And then we've talked a little bit about these questions about reverse engineering and copying. And then also the question, litigation patent in some ways may actually be more straightforward, be extremely expensive. But, you're going to end up in federal court, but you know what right you're taking to court. With the trade secret, I think probably the hardest part of trade secret litigation is how do you define what the trade secret is? Because you want to be really careful writing that down. And so you may not be able to show the court, hey, here's this piece of paper that says my trade secret. Describing what the scope of it is can be very challenging, and that ends up becoming very difficult in litigation. Daniel, I see we're at about time, so I figure go ahead and take some questions.
Yeah, so there are a few questions in the Q&A.
Okay.
Mike, I don't know if you're online and you want to unmute yourself. Otherwise, I'm happy. I can also read the question.
Yeah, sure. So appreciate the talk. Thanks for your time to give it. My question was about the novelty and originality of the patent, which is one of the things you talked about early on.
Yep.
And is that assessed at the time of filing or at the time of potential litigation? Because 20 years from now, what was obvious, well, I mean, if we rewind the clock 20 years ago, what was, yeah, you know what I mean?
I totally know what you mean, and you've hit on one of the hardest parts of dealing with patent litigation. And so novelty is going to be assessed at the time of filing. The question of who filed first. That's the regime that we're in these days. It used to be a question of who invented first before 2011. As you can imagine, trying to figure out who invented first can get very thorny very quickly. Go take a look at the CRISPR litigation if you want to go see probably the last example we're going to see of that. Under the current regime that we have in the United States, the idea is whoever's first to file, that's the point at which you're going to assess novelty. You're partly talking about the non-obviousness inquiry as well, and that is really, really hard. We actually talk a lot about hindsight bias when we're thinking about obviousness, because the exact issue that you're raising, it is really hard if you're looking 10 or 15 or 20 years back to not be influenced by what's happened in the meantime. And so how do you try to get around that? Do your best. You try to look at the types of references and the types of inventing that was going on at the time. You usually go find an expert who was active in the space at the time of invention. And so, I mean, when I was practicing, I oftentimes was talking to folks who, were retired, who were doing these things 20 years ago and who were, at the top of their field at that point, and who could remember back, hey, well, here's what I was thinking about at this time, and this was what was available and this wasn't. Hindsight bias is a huge problem, and it's very difficult to get around. And we're human, judges are human, we do our best. But it is a thorny thing when you're dealing with the question of obviousness in particular. It's a great
Okay, fair enough. Thanks for the comments and insights.
And Magali, are you on?
Thank you for this talk. I don't remember exactly how I phrased my question, but I'm curious to hear your thoughts about leveraging patenting and trade secrets as a means to ensure indigenous data sovereignty for tribes. And so I'm curious if you've engaged with that. So thinking about not just companies and a competitive market, but thinking about communities.
Very interesting question, something that has been dealt with in the courts in the last couple of years. I think, Daniel, can you give me Magali's information? Because I have some things I can send you. I think probably goes beyond the scope of this talk, but I would be happy to send you some resources. I think that the short answer is that there have been efforts to engage in litigation surrounding using the state sovereignty doctrines in order to be able to bring patent cases. They didn't quite work out the way that folks wanted them to in court. And so I would be happy to send you some of that information because it's a very interesting thing.
And there's another question from Chris, which kind of extends the data question about sort of data ownership that AI relied on. Chris, I don't know if you're on.
Yeah, sure. Thanks, Allison. Really great overview of this. Any additional considerations around the data that the AI might rely on, such as if the data are owned by another party or if they're licensed?
That gets thorny very quickly, I think is the short answer to that question. You certainly don't want to be in the game of patenting something that you don't own yourself. And so, if you have some sort of agreement or you have a joint agreement to go forward and pursue patenting in that way, then maybe you can do that. I think I've probably tipped my hand here a little bit in the sense that, I know that folks are pursuing patents on data, including those joint ventures. I'm not convinced that's a great idea. I think that you're probably better off, you know, with trade secret protection on those types of things in many cases, unless you really do have something novel and you're really willing to disclose to the public. I think at the end of the day, if you were trying to patent and something like that, you just have to have robust agreements, you know, and you certainly need to have joint inventors, you know, and really make sure that you're tracing the rights thoroughly. And I think the way that I think about it, I actually come at it more from a litigation perspective. If you eventually needed to enforce that patent, if you needed to take it to court, everybody who has a piece of the ownership, everybody who was involved needs to be listed as an inventor. All of the owners have to come in order to be able to sue. If somebody's left out, that's a really great way for the defendants to poke holes at you. And so if you're thinking about something in particular, I'd be delighted to talk to you offline.
So
Thanks.
one final question, which is, given time, I'm afraid it's a yes or no question from Casper, which is, does one register a trade secret in advance or only assert afterward that it was stolen?
You don't have to register trade secrets. And so you would only assert afterwards that it was stolen. And that's part of what gets thorny about it, is that you don't, you know, you have to define exactly what it was that was stolen. And so how do you, as the trade secret holder, show what it is that you had? And so that becomes very difficult very quick. The identification of trade secrets, I think it's the hardest part of a trade secret litigation, because you have to figure out what the scope is of what's being described.
All right, well, listen, you have kindly offered to receive people's questions offline, etc. And I fear that you may actually get some. We'll post the slides from your talk on the website. Let's just conclude by sending you a great thanks for contributing your time and know-how, and yeah, look forward to continuing the conversation. Thank you.
My pleasure. Please, it's not an imposition at all. Please feel free to reach out.
Bye-bye.
Thanks for a great presentation. Thanks for hosting it, Daniel.
Sure, bye everyone.
Bye.